Good morning, and to hear this case today is very timely since we're expecting a snowstorm and ice storm tomorrow.
We didn't plan it that way, Your Honor.
Okay. All right, well, you've got our full attention with that.
Your Honor, I'm Matthew Jarrett, attorney for the plaintiff. This is Jerry Jarrett. He's also the co-counsel for the plaintiff. He's going to argue on the rebuttal today, Your Honor.
Well, you sure you can't stop him from doing that? So, okay, all right. So glad to have you with us. All right, very good.
Your Honor, this is a case out of Warren County, Tennessee, of our client, the appellant, Mr. Broyles. He and a friend on the morning of January 6th.
Oh, do you want to reserve time for rebuttal?
Yes, reserve time for, I'm sorry, 2 minutes, Your Honor.
2 minutes, all right.
Sorry about that. Yeah.
No problem.
They were out running errands. They went to, I believe, Tractor Supply early that morning for a shopping trip, and they decided after that they were going to go to Hickory Creek Barbecue for lunch. The forecast that morning had been like the forecast, I guess, for tomorrow morning, and there had been threats and watch out, and winter precipitation was on the way. And when they went into Tractor Supply, it was not snowing. When they came out, it was snowing and icing, and they drove to Hickory Creek Barbecue. And this barbecue restaurant is in the middle of a shopping center parking lot, nothing but pavement around it. The appellee, Mr. Herrin, rents it from Duggan, which we had non-suited earlier, and he testified he had built a porch, a deck, where customers could come up. There was also a drive-through where you can get your, meals to go. As Mr. Broyles and his friend went up to the front door, he slipped. It was slick. He slipped, sustained injuries to himself.
So he slipped on the porch?
Slipped on the porch, okay. Yes, he did. Okay.
And was the intention to eat the meal at the restaurant there on that porch?
No, Your Honor. I believe it was. I believe there were tables inside, or either to pick up. It was going to eat on the porch, though, Your Honor. Okay. And so there was no warnings, nothing to prevent them that, tell them there was a slick porch outside. He filed a lawsuit in Warren County Circuit Court. We've had gone through discovery. Actually, we had party depositions about a year ago, this week. Mr. Herrin's counsel, the appellate's counsel, filed a motion for summary judgment, I believe, in February of 2024. It was heard in front of Judge Stanley in, I believe, in late March of 2024, and he ruled against Mr. Broyles and granted summary judgment to the appellee. Our argument today is that this is a question for the jury. I believe Mr. Herrin, in his brief, stated that the removal of snow and ice was the apparent issue. When we filed our complaint, we did acknowledge that snow and ice should be removed. We also argued that the landlord or the business owner should have taken actions to prevent us,
So this boils down, though, to a question of duty. Right?
Duty.
And that's a question of law for the court.
Yeah.
So the question is, what was the defendant's duty as to these steps at the time of the accident?
Well, case law says a reasonable duty.
Reasonable duty, that's right. Yeah. And the case law says you have a reasonable time to sweep off the steps, and it, there's not a automatic duty of the moment it starts snowing to run out and start sweeping.
Well, I believe the appellee's testimony, his deposition, that's part of the record, is that he had a rope or a chain that he fastened to keep people off the porch, or instruct his employees to do the same if he wasn't there. So we would argue this is not a not a challenge. Doesn't have a high cost. You walk out, simply attach the rope, and have people go through the drive-through when it's bad weather.
I'm having a hard time understanding that, though, because the snowfall or icefall or whatever the case was here happened in close proximity to the time that the restaurant itself opened, correct?
It did.
Yeah,
It did.
so, I mean, what you would be suggesting then is really, the moment they opened it up, they just should have roped off the front door and only opened
No,
the
the moment they saw precipitation, and it had been falling for, I believe, at least 20, 30 minutes.
Okay.
They could have, according to the appellee, he could have just fastened the rope
And
to
so
keep people off the porch.
The timeline here is the stop at Tractor Supply about 10:20, 10:30, trip over to the barbecue restaurant, fall at 11:15 roughly that same morning.
Yes.
Okay.
Yes.
And the precipitation would have started, or icefall or snowfall would have started somewhere in that 45-minute range because it happened while they were in Tractor Supply.
Exactly.
Okay.
When they came out, it was going pretty good, so to speak.
Is there any factual dispute here that you can point us to that is significant, that's material?
Yes, the fact that, well, I guess argument would be that a jury can consider whether the appellee's actions were reasonable or not.
Right,
Yeah.
and I understand that argument, but what about a factual dispute?
No, there's no factual
Okay.
dispute here, Your Honor. No, there's not. As I say, our argument in the fact that a jury should hear this. They may find for us, they may find against us, but still a jury should make that decision. And that's why we feel like a summary judgment's inappropriate in this regard. You know, in the brief that we submitted, the case law says it's a jury fact. Even if there's an open and apparent danger, it's a jury consider whether that the plaintiff took reasonable actions to avoid that danger, and if the defendant had a reasonable duty to prevent the plaintiff from encountering that danger. And we would ask this court to reverse the summary judgment of the trial court and send it back so we could have a jury make a decision on this.
All right, thank you, Mr.
Thank you.
Jarrett. We'll hear more on rebuttal. Mr. Smith, good morning. And as I said earlier, it's quite timely that you have this case.
It really is. Good morning, Your Honors. I'm Warren Smith of the Nashville Bar. This is a undisputed fact case, as the plaintiff just stated. Mr. Broyles had been in Tractor Supply. It started snowing. For what period of time? 15, 20, 30 minutes. They went to the barbecue place to order barbecue. There was snow beginning to accumulate on the parking lot and in the area, but it's within 15 to 30 minutes max. Now, the plaintiffs in their lawsuit have alleged that the barbecue restaurant was under a duty to clean and remove the snow at the time Mr. Broyles fell.
He also brings up something about a rope.
Right. I will address that right now. I assume that's the only issue that I see.
Well, so, I mean, the idea that rather than opening that morning, what was the opening time for the restaurant?
11.
11 o'clock. So rather than opening that morning, they should not have opened the front door, but, I mean, they could have kept the drive-through. That's really what we're arguing about, I take it.
That's the plaintiff's best argument. Their initial argument that we should have cleaned the snow, the case law that I have cited is fairly clear that when in this subset we have general law that they cited about the duties of a property owner, then we have law about snow and ice trip and falls where the time after the snow stops. And then I would submit there's a subset of law in this case about cases where the snow is continuing and has not subsided at the time of the fall. And that's the Clifford case and the Chittenden case, I believe is how you pronounce that I've cited. The Clifford case is similar factually to this case. People went to State Farm to pay their their insurance premium during a snowstorm. Upon leaving, the plaintiff fell and injured himself, and their allegation was that he should have taken steps to clean the snow or warned us that there was snow on this wheelchair ramp. The court held that no, there's no duty at that point in time while it was snowing. Judge Cope said because the snow had not yet ended, Crye-Like's duty to begin removing snow had not yet begun. And that's essentially...
Does the same reasoning apply to putting up a rope?
I would say it does, because it also, in that case, said there's no duty to warn. And in putting up a rope, it's a plastic chain that's just normally used to hook at the time the store's closed. I would submit is a form of a warning. Warn people, do not come up here. But we're talking about a situation that is within, at best, 30 minutes after snow begins. At worst, within 15 minutes after snow begins. And to require a business that has a drive-through window, alternate means of providing its product, to close its doors immediately upon snowfall is absolutely not reasonable. And under this case law, there's no duty to do that. Until this snowfall stops, the landowner is not under a duty to do anything. In the Chittenden case, it went further and said that he's not even under a duty to go out and monitor the situation to find abnormally dangerous conditions. That is the state of the law in Tennessee, and our position as defendant is that there was no duty to clean the snow, there was no duty to warn, there was no duty to go out and make a search for abnormally dangerous situations based on these cases. And without getting into the issue of reasonableness, I'm going to stay within my duty argument, without getting into the reasonableness issue, to require a business that has a drive-through window operation to close or not open within 15 minutes of the beginning of a snowstorm is just absolutely unreasonable. The effect of that, you're thinking in the long term, the next argument is every McDonald's, every fast food restaurant, every bank, every drugstore, the precedent, if that's the law, that if you have a drive-through window, you have to close to protect the patrons. That is not reasonable.
Let me ask, is this chain or rope, whatever it is, was it put up normally just to show the business was closed?
Yes, sir.
So it wasn't really used for weather purposes?
There was testimony that from Mr. Herrin's deposition, when Mr. Jarrett asked him, well, what do you do about snow? It came out, well, if you're big enough snow we're closing, we'll put the chain across the gate.
If they're closing?
Well, if they're closing the front entrance.
Yeah.
The front entrance. But in this case, that was nowhere near in their minds because the snow had just started. It had just started.
Thank you.
And their second allegations in the complaint that I addressed was the one about the winter storm warning. There's case law says that a landowner is not required to take any steps to protect people from snow that has not yet occurred. That was in the Bowen case. Says no case has ever imposed a duty on a property owner to constantly monitor weather forecast or to take steps to prevent or forestall possible accumulations of ice and snow. Those issues were presented to the judge on summary judgment under the argument of there's just simply no duty. That is our position today, and we ask that the court's grant of summary judgment be affirmed.
All right. Thank you, Mr. Smith. Rebuttal? Good morning, sir. Welcome.
Good morning, Your Honors. I'm Jerry Jarrett from the Canadian Bar. No, I'm really not, but I just want to point out that today is January the 9th, and our client got hurt on January the 6th. And yours truly started his law practice 55 years ago on January 3rd, I believe. So January is a pretty important month.
My goodness.
But at any rate, it's true that Mr. Smith and I have been friends a long time. He's a great lawyer and so forth, and does a good job, and we think we do too. But I just want to state that the nutshell of this case is whether or not there are facts here in this file that a jury should consider. And we believe that, first of all, I've never seen such a short order from a trial judge on overruling a summary judgment. We didn't touch on that, but anyway, not many findings of facts were there. But anyway, the issues are, we think, is whether, I'm not talking about, of course, there are duties involved. And in my 55 years of operating a business in Cookeville, Tennessee, and we have a estimate from the weatherman what's going to happen tomorrow, we're closing, and so are a lot of other businesses if you care about the public and are not negligent in keeping it out. So anyway, one issue we think is whether or not the defendant knew or should have known bad weather was coming, that include ice and snow and dangerous condition. Look, most good business owners check the weather in January, particularly every night, and there was plenty of warnings for this coming. And the defendant testified in his deposition that he did have a procedure that he followed, that he thought ice and things and dangerous conditions were coming around for his clients, including older people like me, that he would close his walk-in business, but would keep his drive-in business going. And we don't question that. That's not an issue. Well, yes, the drive-in would have been fine. We're not arguing that. But he should have either closed the business like he did do every time, or he should have certainly should have looked at the weather forecast and made corrections on that. And thirdly, we think he was negligent in preparing contingency plans for bad weather and told his employees, either written or oral instruction, he couldn't remember, in handling inclement weather conditions. This business opened at 11 o'clock. His employees had to open the door to open the business. There the ice was already started. The plaintiff was somewhere else. He should have picked up a phone. He knows how to use a phone, and called his employees, says, rope off that front like we've been doing and continue the drive-in. So, but these are fact issues we think a jury should do. And so, and again, the defendant says he usually closed his business or roped it off for the walk-in people when bad weather was coming. And he should have called his employees and say, hey, shut this thing down. Somebody might fall. Anyway, that's a jury question. Now, we may go to trial, and thank goodness the state of Tennessee does have comparative fault. Great law. But anyway, I think that our client is due as the jury to decide some of these facts.
All right. Well, Mr. Jared, like Mr. Davis in the prior case, an honor to have you visiting with us today. And Mr. Matthew Jared and Mr. Warren Smith, thank you. Good to see you again.
Thank you. Another important day in January. Today is my birthday.
Oh, my goodness. Wait, I didn't, you 85, is that right? gate, is that right? Well, congratulations, it's a momentous month then, my goodness, all right. Well, travel safely.